no.
I stole on them.
For the Voir demonstration, we've got two people that y'all may recognize, or at least one of them we have from the county attorney's office weighing in at, and
No, please, no.
no, please don't. No ages and no limits. Is Ann Foster, who is the chief prosecutor in County Court Law Number 5. I'm sure some of y'all have dealt with her at this point. I'm sorry about that.
I wear my buttons specifically. It says psycho bitch from hell.
We took a vote and all of us gave her that unanimously.
That's right.
But she is a graduate of Smith College, which is a small radical liberal college in the Northeast, where rich people go. And a graduate from UT Law School in what year?
1985.
85. Serious Law School, and has been county attorney's office several years, and a good prosecutor, and we're pleased to have her here. On the defense side of this demonstration is Steve Brittain. Steve and I graduated from law school together here in 1912. Shortly after law school, he entered the county attorney's office and established an immediate reputation for being a liar and cheater, so well that he immediately was promoted thereafter to the district attorney's office, where Steve prosecuted quite vigorously and successfully for a number of years. Has been in private practice, worked with Boyd Mitten's firm for a while, has been out with his present group of Andy Forsyth and Alan Williams, all good lawyers, doing criminal defense work all over the state of Texas for the last 10, 12 years, I guess it is. It seems longer. Very good defense lawyer, lots of jury trials, and a very successful trial lawyer. Doesn't always play things by the book, but is always successful in what he does. So we'll leave it to you.
Each lawyer will have a total of 30 minutes apiece to do the voir dire. Okay. Okay. Bill?
Who's my bailiff? Did you go get me a Coke?
You don't have a
Make up Pepsi. Give me 5 of them.
We'd be happy to get that for you, Judge.
All right. Call case for trial. Stay ready.
State's ready, Your Honor.
Defense ready?
That's good, Your Honor.
All right. Each of you have, I'll give you 30 minutes. State may proceed.
Thank you, Your Honor. Please, court, counsel, and members of the jury. I'd like to welcome you here to this court for this procedure which we call voir dire. Voir dire is my opportunity as a member, I represent the state of Texas in this case, is an opportunity for me to ask some questions and to get y'all to talk to me. And what I'd like to do is to have you understand the purpose for which we're here, and that's why I start out this way. It's my job to see if I can pick out of the members sitting out there, if I can pick individuals, enough of them, who are fair to the state and to the defendant in this criminal case. Today we're here on a criminal case, which is a driving while intoxicated case. And I need to get y'all to talk to me about how you feel about DWI, what you think about it. If you are indeed the proper person or the right person for this trial, there are certain trials where people just aren't right. For example, if I were on a DWI panel, I might not be the best person to be in the position of judging a case such as this because of what I do. I prosecute people in criminal trials. So it may not be that I'm the best person. It doesn't have anything to do with what you are as a person. There's no passing judgment on what you are here for. I'd ask, though, that you answer the questions as best you can. There's no right or wrong answers. And if there is a personal problem that you have about speaking in front of a large group, perhaps Judge Allison can afford us the opportunity to approach the bench and talk to him and afford you some privacy up there. So, since we are talking about DWI, I need to ask y'all some questions. Is there any one of you, say Mr. Burleson, you're a student, have you had any experience with a driving while intoxicated case?
No.
Okay, not you or friends of yours here at the university? Are you at the university?
Yes, ma'am.
Okay, nobody that you know has been arrested, or have you talked about a DWI case with any of your buddies or anything?
I have some distant friends I know who are in fraternities that have gotten some DWIs, but
Okay.
none of my close friends have no idea.
Okay. Ms. Ford, how about you? Have you had any experience one way or another, a victim of a DWI accident?
No.
Your husband is an attorney?
Yes.
What kind of law does he do?
Civil law.
Okay, does he come in contact with anything like perhaps civil litigation involving a DWI?
No.
Personal injury arising out of that?
No.
Okay. Mr. Byrd, how about you? Any involvement with the DWI in any way, either as a victim, you know, a victim member of your family, a friend, yourself?
I've had some friends, and I've known a victim of
Okay.
DWI.
Well, let's talk a little bit about that. First of all, you've known a victim. Who was it, if I may
A
ask?
friend of mine in high school.
Okay. And how long ago was that?
That was about 10 years ago.
And were you close at the time?
Yes, we were real good friends.
And how was it that person?
Your Honor, I have a point. Well, can you approach the bench, please?
Yeah, you may, just pro forma, just, what's the problem?
Judge, before we get into the broken arms and legs and blood out in the street, I'd like to have some idea of what we're talking about here in terms of this victim and what the relevance is to prosecutors for
All right, you want to ask him some questions and bring him up to the bench? Assume witnesses at the bench. Okay, go ahead.
Mr. Byrd, just give me a thumbnail sketch of what you mean when you say victim of the DWI. You're talking about
A friend of mine was killed in high school in a DWI-related accident.
all right, and was that case prosecuted? Do you know if it ever?
I don't believe it was,
Do you know why?
because the driver was killed too. She was riding in a car driven by a drunk driver.
Needless to say, that was a very traumatic experience for you. Is that correct?
Yes.
And, what we're here today, and the prosecutor's doing a very good job of talking to you about, some people may or may not be the proper juror in a particular case. Is there anything about that experience that would make it more difficult for you to take your oath as a juror on this case?
No, I don't.
So you can put that out of your mind. So it was not particularly traumatic for you. You were not that close to the person?
Well, I was close, but my relationship with her would have absolutely no bearing on how I would decide someone else's fate in a trial.
You understand there's no wreck in this case, no one was harmed, and that
I
it's two
guess if you
totally
tell me
different
that, I believe
situations. You appreciate that, and that this is
Sure.
not, that case that you were describing is not a DWI. In fact, if prosecuted, it would have been involuntary manslaughter, a felony, a much more serious situation than we're dealing
Okay.
with. All right, that's all the questions I have, Judge. I would ask, though, that in terms of this particular area, that the question, if she has any further questions about that incident, that we take those up at the bench and not in the presence of the rest of the panel, Your Honor.
Someone want ruling on that, or what?
Just making the request, I'm sure the prosecutor will honor it.
Your Honor, I think I have a right to question the jurors as I see fit, and if there is some sort of information that is elicited from this particular juror at the bench here, that I have a right to question the other jurors along those same lines, and if the judge so wishes that I cease questioning on this line with this witness, this juror, I would ask at least the ability to ask those same questions from the other juror.
Why don't we just get on with it, and if you see a problem, Mr. Brittain, you call to my attention.
Thank you, Your Honor.
As it goes.
Okay, so Mr. Byrd, there's nothing involving this particular case with your friend as a victim that you would keep in mind during this trial of the DWI?
No.
Okay. You mentioned before we approached the bench that there were some friends that were perhaps involved with the DWI. Could you explain to me how that has occurred?
Well, I've just had some buddies that were caught and they had been drinking while they were driving.
Okay, is this recently?
No, it was several years ago.
And were they prosecuted for DWI?
I believe a couple of them were, some of them were not.
Okay. And you're a businessman, you are employed, or your employer is Presidio Enterprises?
Presidio Enterprises.
What does
right.
Presidio Enterprises do?
They deal with real estate here in Austin and in Manor, out where I live.
And so these friends were just, do you still see them and do you talk about these particular incidents?
I haven't seen some of them in 6 or 7 years.
And you personally have never been involved, were you present with them when they were pulled over?
No, it was not.
Okay. And
In
you-
fact, one of them, it happened while he was out on vacation in California. So I wasn't with him.
Mr. Daly, how about you? Have you been involved with a DWI victim or a driver or?
No, ma'am, I haven't.
Okay, and nobody in your family or acquaintances have been arrested or involved in?
No, ma'am, I haven't.
No victims involved either?
No.
Okay. I guess what else I need to talk to you about is particularly your experience with alcohol. Since it does involve you judging someone who has as the state sees it, taken ingested alcohol into their system and has been basically charged with the crime of driving while intoxicated. I need to talk to you about what y'all think about drinking alcohol and basically try to explain to you what intoxication means. The legislature has defined, well, basically the charge of driving while intoxicated means that the state has to prove to you beyond a reasonable doubt that the defendant on or about a certain date while in Travis County, Texas, was on a public road, street or highway, was driving while intoxicated. And those are the elements that the state has to prove. Further, the definition of intoxication is that the defendant, or in this case, Mr. Victor Alvarez, had lost the normal use of his mental or physical faculties due to the introduction of alcohol into his system. So or had an alcohol concentration of 0.10 or greater. So what that means is that the state has to bring you evidence of what it is to prove intoxicated, the evidence of intoxication. So I can bring to you evidence of loss of the normal use of his mental faculties, or loss of the use of his physical faculties due to the introduction of alcohol, or having an alcohol concentration in his blood of 0.10 or greater. So along those lines, is there anyone who has never had a drink of alcohol in their system? Okay, Mr. Dowd, you just have never tried alcohol?
That's correct.
Oh, okay. Can you tell me why it is?
I believe that we're all part of God and that we're sacred vessels, our bodies are sacred vessels of the Lord, and that alcohol is an impurity and it's a sin against not only ourselves but against our Lord.
Okay. And this is obviously a religious belief that you hold?
Yes, ma'am.
Okay. And do you belong to an organized religion?
Yes, I'm a Protestant.
Okay. Do you, in the Protestant religion, do you feel that those who do ingest alcohol are people who are, well, how do you feel about people who do drink?
I feel that it's a sin to themselves as well as to others.
Okay.
I personally don't drink alcohol myself, and I don't believe in it.
You respect, though, the ability of others to choose differently than yourself?
I think so, yes. But my personal belief is that it's wrong.
Okay.
And if they choose to sin, then it's their problem.
Okay. So are you telling us at this time that if a judge were to ask you to follow the law as it occurs in the state of Texas, that it is not illegal for someone to drink and then drive, but that they have to drink to the point of intoxication? Are you saying that because they haven't even taken one sip of alcohol that you would not feel comfortable in judging their behavior? Or that you would already have prejudged them?
Well, if the judge tells me what the law is, then I would go with what the judge says.
Okay. And would you then be able to put aside your personal feelings about people who drink and follow the law as the judge asks you to? Would you ever put aside your personal feelings?
Yes, I think I could.
Okay, thank you. Mr. Bird, how about you? Have you had an opportunity to ever take in alcohol into your system?
I had a few drinks.
Okay. Have you ever been under this definition that I've talked about, what we would call intoxicated?
Probably.
Okay. Well, let's talk about have you ever been drunk?
Probably.
Okay. And when you've been drunk, let's see, can you understand, or do you understand the difference that I'm trying to get at between being drunk and intoxicated?
I think so.
Okay. Think of it on a spectrum. If you're sober as a judge on one hand and you're drunk, say commode hugging drunk on the other hand, there's a continuum of, say, 0 to 10 on that space, on that line. And when we're talking about intoxication, we're talking about the lower range of in taking alcohol, such that when your normal use of the physical and mental...
The law, Your Honor, there's nothing about ranges or scales that will be in the court's charge, and I think she's intentionally trying to mislead the jury in terms of what the definition of intoxication is.
I have no intention of misleading you by any stretch. Certainly not trying to mislead you. I'm really trying to get a concept over and to explain it a little bit. But, for example, if you took, what do you prefer when you do drink? What do you prefer to drink?
Beer.
Okay. When you take that first drink, when you order your first beer, how long does it take for you, drink to start feeling a little bit differently?
Well, that depends on, how much I've had to eat.
Okay, well, let me ask you this. When you go, after work, say about 5 o'clock or when you kick off, and you go home and you get a beer out of the refrigerator, why are you picking up that beer?
Well, if I'm by myself, I won't have anything to drink. I don't drink by myself.
Okay, say there are...
If there are buddies there or something, probably a ball game's coming on or something like that.
Okay, but are you taking that beer then only to enjoy yourself, right?
Right.
Okay. And when you drink that beer, you're looking for a feeling, are you not? Or do you particularly like the taste?
It's an acquired taste.
Okay.
I guess I've acquired it.
So necessarily, when you first started to drink, you weren't starting to drink because you liked the taste of the stuff that you're putting down your stomach, are you? You're right. You're looking for that feeling, that buzz, right, that you first get after a couple of drinks, perhaps.
Maybe.
Okay. Put yourself in that place when you're starting to feel that way. Okay. And tell me if you can describe to me and the other jurors what it felt like. What are the physical things that you're doing that are different? What is the loss of your normal, say, normal use of your physical faculties? What are the things that you feel going wrong? And especially for Mr. Daly, who says he's never taken in alcohol. Tell him what it feels like and what you're doing differently.
I think probably your inhibitions are lessened somewhat.
Okay. And how is that manifested to a third party or to another person, that your inhibitions are lessened?
Well, it would depend on whether they've been drinking, but to be able to pick that up, I would guess someone that's stone sober, they might be able to tell. I guess a lot of that depends on how much you've had to drink.
Okay.
If you've had 20 beers, they'll definitely be able to
Okay,
tell.
well, let me ask Mrs. Ford. Mrs. Ford, have you ever had alcohol? And did you drink alcohol?
Occasionally.
Okay. And when you drink, have you ever gotten to the point, say, that you might think that you were intoxicated under this definition?
No, I don't think so.
Okay. But have you seen people who are intoxicated under this definition?
I think so.
Okay. And have you seen people who are drunk under this definition?
Yes.
What's the difference between the two? When you see someone who's drunk, what are they doing?
I guess I think of someone who's drunk as falling down and not being able to control themselves.
Okay. And what you're seeing perhaps is that they've completely lost the normal use of their physical faculties. They're falling down. They can't coordinate their muscles well enough due to the introduction of alcohol into their system. All right, take that one step further. What do you see when you see somebody who's intoxicated?
I'm not sure I understand the difference.
Okay. If when you drink, what do you drink?
Wine occasionally.
Okay. And how much do you usually drink when you sit down?
A glass or two with dinner.
Okay. And are you stopping for a particular reason? Do you stop drinking because of a particular reason?
No.
Okay. Well, maybe Mr. Burleson can help us out here. Mr. Burleson, have you had alcohol in your system before?
Yeah.
Okay. And do you drink often than not, or how often do you drink?
Less often than I do, but probably fairly often.
Okay. And have you ever been under this definition, what we might call intoxicated, as opposed to drunk?
I've been both.
Okay. And in order to perhaps help Ms. Ford in explanation, see, I can't tell you. I have to sort of get some information a different way. I'm under constraints by the rules of evidence. When you have been intoxicated, what do you like to drink? Let me go this way.
Depends where I am, what day it is.
Okay, say you've had a hard, you're still here at the university?
Right.
Okay, you go out with your friends after school, or say after seminar at night. You go down to the Posse, is that still here at the university? Okay, say you go down there and you order something to drink. What might you have, a beer?
I drink beer.
Okay, and when you have a beer, do you feel any different after that first beer?
Yeah.
Okay, how do you feel?
Well, you're starting to relax, take in the fellowship, just hanging out with your friends, and
Okay.
I mean, you may not feel physically affected by the first beer.
Right, but you said something really important, and what you said was, I started to relax, okay? You're taking in alcohol for a specific purpose. It's to help you relax, right? And it changes you. It relaxes you. It takes you out of the normal use of your physical and mental faculties. You enjoy the fellowship of your friends. Perhaps the cares of the day go off, they slip off your shoulders a little bit, and you enjoy the fellowship. Okay, second beer.
Well, if I could explain one
Sure.
thing. I didn't necessarily mean to indicate that the first beer made me physically relaxed. I kind of just meant the environment, the ambiance of the whole scene.
Okay.
It's kind of more relaxing than a stressful day with a seminar.
Okay.
So,
Okay.
no, after
But it started,
several
would you
pictures-
agree, would you agree with me that it starts the process?
I don't know if I'd say that one beer would make me any more relaxed than not having a beer. I think it's just just where I am, what I'm doing, what we're talking about,
Okay.
watching a game instead of being at school.
How about 2 beers?
Yeah, then I think something.
Okay. Say you are intoxicated under our definition. How are you acting? Are you acting any differently?
Intoxicated from 2 beers?
From any, pick your number of
Okay.
beers.
A lessening of inhibitions, just relaxed, a little more open.
Okay. Do you ever get a little bit unsteady on your feet? Have you ever said things perhaps that you wouldn't normally say?
Yeah, you may.
Okay. Have you ever lost physical coordination a little bit, say dropped your keys or spilled a beer perhaps like gone to touch someone and then mistaken?
I don't think the physical incoordination is really associated with the early part of the spectrum or intoxication.
Okay, we'll move on the spectrum a little bit, okay?
Maybe drunk or commode hugging.
Do you think that a person becomes drunk like that? Do you think that they lose the coordination, as Ms. Ford was talking about, or Mr. Berg was talking about, that they take in enough alcohol and there's no process of getting to the point where they fall over drunk?
No, I don't.
Okay. So there is a process.
Right.
So let's talk about that process point where you are aware of someone else or even yourself. Maybe it would be easier easier for me to get some information if I concentrated on the fact that you see somebody else. Say I took in alcohol, took a bunch of drinks, okay? And you formed the opinion that I was intoxicated, that I was on that process, that road down to being commode hugging drunk.
Right.
What would you see me doing? What would I be doing that would make you think that I was intoxicated?
Well, unless you were blatantly commode hugging drunk, I'm not sure I could determine that you were drunk because I don't know you well enough to know what you're like when you're sober.
Okay.
I have friends that I would think were drunk who are entirely
Okay, so
sober.
if you see your friends who may be along that process, what do you see them do?
Getting a little more loud, saying things they may not otherwise say, laughing a little more, maybe.
Okay, have you ever gotten into a car with a friend who perhaps has had too much to drink?
Definitely.
Okay. And was there anything about their driving that scared you?
No, I wouldn't. Not enough to characterize it or
Okay.
generalize.
What then made you think that they had too much to drink?
Because I was with them and
Because you knew how much
obviously
they had
a
to
lot
drink. Okay. So let me go back to Mr. Daly. Have you ever seen anybody who's intoxicated? You may not have known anybody personally.
Yes, I have.
Okay.
I think it's shameful these days because all these young boys and girls, the way they carry on, cavorting around, barely dressed, and drinking days and nights, and just throwing up all over the place, polluting the streets. I think it's just shameful.
Okay. Thank you. Let me ask y'all this, then we'll move on a little bit. Has anyone, this case particularly involves a UT police officer. Has anybody had any experience with the UT Police Department at all? Yes, Mr. Daly.
I have a family member who's a police officer.
Okay. And with what police department is he?
With the Austin Police Department.
Okay. And do you talk to him at all about his job?
From time to time, I do. But
And how is-
he's not a really close member, so I really don't see him that often.
Okay, how is he related to you?
He's my brother-in-law.
Okay, so your sister is married to him?
Yes.
Okay. Are you married at this time?
I'm divorced.
Okay. And Mr. Byrd,
Yes.
how about you? Have you had any involvement with UT Police Department at all?
Just several parking tickets.
Okay. Anything about that? Do you think you were ticketed illegally? Anything about that that would make you think more or less of a UT Police Department officer?
I think a couple of times they were wrong. I think I was correctly parked.
Okay, these are parking tickets. Did they leave the ticket on your car?
Sure.
Okay,
That's
so
how
you
I-
didn't really have any personal involvement with them?
Well, a couple of times they'd be ticketing my car, and I'd talk with them about them ticketing my car as they were doing.
And did you feel that they were, can you give me some information about those particular incidents?
There would be a time zone, and I would be, it was 15-minute time zone, and they would come along and slap a ticket on there, and it had been 15 minutes.
Okay.
And I would just ask them how they knew how long I had been there, whether
Okay.
they had a stopwatch on me or something.
And do you feel that you were wrongly ticketed then?
A couple of times. A lot of times I was in the wrong. Most of the time I was in the wrong, but a couple of times.
Is there anything about those incidences that would affect your ability to sit on this jury and to listen to testimony from a UT police officer?
No.
Okay. Do you, 5 minutes? Okay. Anybody had any of the bad experiences with the police officer, UT or otherwise? Mr. Burleson or Ms. Ford?
Not bad experience.
Okay. You've had an experience with
Well, I've
police
lived in
officer?
Travis County for 20 years.
And how is, and could you tell me, just give me an idea of how you come in contact with police officers before?
One time I was arrested for outstanding speeding tickets. My roommate was arrested for outstanding speeding tickets, and the police officer came and got him out of bed in the morning. I was in the 6th grade. We were throwing stuff at cars on a moped, and a police officer took us home. And he's come to the fraternity house several times and kind of told us to turn things down.
Anything about those experiences that you would hold against or for a police officer?
Not at all.
Okay. Ms. Ford, how about you?
Oh, no, I've never had any contact with
No. Okay. Has anybody had any experience with either watching or seeing or doing field sobriety tests? Does anybody particularly know anything about field sobriety tests?
See them on TV every once in a while.
Okay.
You watch Cops or something like that.
Right, you're talking about a basic nose touch test, maybe.
Right.
They do make
Alphabet.
parodies. Would you agree that perhaps that's not necessarily real life? Have you seen the Tracy Ullman characterization of field sobriety tests where she's running up and down and doing flying across the room and stuff? Well, the field sobriety tests are generally allowed, are an investigatory tool that police would use in order to determine the loss of physical faculties or mental faculties. And the officers will be describing to you what those are, what they're looking for, and what they saw in the particular actions of Mr. Alvarez that night. Okay. The next thing I need to talk to you quickly about is the intoxilizer. Does anybody have any information or an opinion right off the bat, a gut reaction about the intoxilizer instrument? Intoxilizer instrument is that instrument that is used to determine the alcohol concentration of someone's breath or blood by them blowing into the machine. You might have heard something about it. Does anybody know anything about it?
They blow into a machine and it tells them how much alcohol there is?
That's correct. What it is it's based on some scientific principles, and we plan to call a expert on that particular issue to talk to you about the intoxilizer, what it does, what it can do, how it's maintained, and the results that apply. That's one of the ways in which we can bring you evidence that shows that the defendant was driving while intoxicated. It's one of the definitions that the legislature has given us as a way to prove intoxication. If that person's result is above 0.10, then he is by law intoxicated. I noticed that you're a little bit hesitant about the idea of that. Can you explain to me why?
I just don't understand that at all.
Okay. Would you be willing to listen to an expert talk about that kind of evidence?
Sure, I'll listen to him.
Okay. Would you be able to consider it, or do you think that it's just something that is just hocus pocus?
I guess if somebody comes in here and tells me that they believe in somebody blowing into some machine and it tells them how much alcohol they've had, then I guess I can listen to them.
Okay. But would you consider that as evidence if it were properly admitted and the judge asked you to either consider it or not? Would you be able to consider that?
Whatever the judge says, that's what I'm here to do.
Okay.
Ms. Faulkner.
Pardon me?
1 minute.
Okay.
Wrap up.
Thank you. Is there anything that, since the judge is asking to move on, is there anything that anyone thinks of at this time that they think that they ought to tell me about their background or personal experiences? Perhaps makes you feel that you should step forward as a citizen to say, I'm not necessarily the best person for this kind of trial. Is there anyone for religious, moral, philosophical reasons feels that they cannot sit in judgment of another person? Mr. Damon?
Oh, I think I can sit in judgment.
Well, I thank you and I appreciate it for your answers to my questions. Thank you.
In fairness to Ann, apart from establishing a rapport with our members and getting them to talk, which is really the best thing to do, she would cover a lot of legal issues, definitions, and things in the normal board that would take a little bit longer. So I'll be responding to some things that she would do normally that she didn't do today, and it's a little confusing. Can I proceed, Your Honor?
No.
Thank you. I'd like to begin, as the judge told you, my name is Steve Brittain. We have, as you probably noticed when the Assistant County Attorney was talking to you, we have some information sheets that you filled out. We appreciate that very much. I like to begin every Voir dire by telling you that we appreciate you being here. We know, we don't talk about it a lot, but we know that if you want to get out of jury service, it's not that difficult to do. And that this is an inconvenience in varying degrees to everyone who comes down here. We appreciate you coming down here. I'll say that, but let me also say that it's, I think it's a privilege that we have to participate in our government in a very direct way. This is not a big publicity case. It's not a case that's going to get a lot of notoriety or go on for weeks or months. In fact, I'm going to tell you a little bit about how long I expect it to last so that you can talk to me about your time constraints if you have any. But that doesn't mean that it's not an important case, both to the state of Texas and to my client, Mr. Alvarez. There are lawyers who've done this a lot longer than I who will tell you that if you essentially take the First Amendment, freedom of speech and religion, and the right to a jury trial, you leave that in the Constitution and take the rest of it out, you'd still have something a little bit like in America there. That's how important it is. And I appreciate your participation. Let me tell you, we don't mean to pry when we ask you these questions. It helps us go through this process and not have to go down the row and ask everybody all of these questions. I am, as you know, an attorney. I'm 43 years of age. I've got three youngsters, one in elementary school that I don't mind telling you about, one in junior high. I'm a little bit hesitant, and one in college, and I'm not going to talk about her for obvious reasons. I have not served on a jury. You have to tell us about that. And another reason I talked to you about, give you that little civics discussion there is because I probably never will get to. Because I'm an attorney and I've been on the prosecution side for a number of years and been on the defense side, I doubt that the lawyers would allow me to stay on a jury. And I'm not sure that I should because I might have prejudices and biases, those are nasty words, but what they really mean is that I might have some predisposition or some knowledge about the process that would keep me from being as fair and impartial as you could be, for example. The reason we talk to you now, the reason we ask you these questions at this stage is that in a very few minutes, the judge is going to ask you to rise, those of you who are selected on the jury, and either he or his clerk, Ms. Johansson over here, will ask you to raise your right hand and administer an oath. Now that oath will be as follows, that you will a true verdict render according to the evidence and the law in this case. Now, a true verdict render according to the law and the evidence in this case. That's what we all want to do. It's That's what all jurors want to do, the right thing, and follow that oath. If, after you take that oath and you sit down and you're seated in the jury box, it comes to your attention that you have a problem serving in this case, following that oath, it's too late. You can't say King's X. So that's why we have to give you this opportunity, and that's what I really want to do. I'm not going to pry. There are books written about whether you're left-handed and wear glasses and a certain kind of clothes, what kind of jury. I think all that's nonsense. I want to cover some issues, and I want to give you an opportunity to talk to me about your ability to take that oath. I think this case will last about a day and a half. If any of you have any economic, business, personal reason why you could not give this case your full attention for a day and a half, I'll give you an opportunity in a minute to talk to the judge about that. What happens, so that you'll be a little more comfortable about the process, is that after you take the oath, the state of Texas will put on their case. They go first. They have the burden of proof. I'm going to talk to you about that. We have an opportunity to cross-examine their witnesses. They will rest. At that point in time, we have an opportunity to present evidence if we so choose. We do not have to. We have no burden to present evidence and bring evidence to you. We close. If the state wants to bring witnesses in rebuttal of anything we said, they can do that. We get an opportunity after that point in time to visit with the judge about the law. He will prepare a written charge, something that looks a little bit like this, that you'll get to take back to the jury. You won't have to memorize it or to pay attention to what the lawyers have told you they think the law might be or could be. You'll have it in writing. You get to go back and read it, and you'll know everything you need to know in terms of definitions to decide this lawsuit. One other quick statement, and then I want to ask you if you know any of the participants in this case. There will come times, and you've seen it already, where the lawyers will object. That's not in any way to be rude or unkind, and I assure you that Ms. Foster will have occasion to object to something I do. There are rules that we have to go by. She said at one point, I believe, in her voir dire that she was constrained and couldn't tell you something. She certainly didn't mean to imply by that statement that she was holding back anything that might be relevant in this case to my client's guilt or innocence. What she meant is that she is constrained, as we all are, as jurors are, by the law, by rules. And in that regard, there may be an occasion where you're asked to leave the room. I always wonder about that. What a juror says, my gosh, what, all the fun stuff is going on while we're back here talking about the football game. Not so at all. We are trying to make sure that the case is tried correctly, so it only has to be tried once. That's very important, again, for both parties. At this point, I would ask you, and I won't now for demonstration purposes, all the witnesses' names and my client and any friends and anybody else, if you know anybody. Does anybody know any of these people I just named? Thank you very much. The prosecutors told you this is a driving while intoxicated case. DWI. Some states, DUI, I think they call it. A lot's been written and said about DWI. There are organizations for them, others against drunk drivers, and other organizations dealing with this crime. Let me ask you, pick on you a little bit, if I can find my sheet here. Mr. Burris, what do you think this law is about? What's it designed to prevent?
I think it's a good law. It's designed to prevent people who are too drunk to get on the road and drive a vehicle, and everybody interested.
Because what happens when that happens? What's the cost to our community and our society when that sort of thing happens?
Well, sometimes there is no cost, but oftentimes there's a wreck and a death.
Property damage,
Right.
physical harm, even death sometimes. That would be a different type of offense, as we talked about earlier. But you think that's what this law is about, what we're trying to get at, what we're trying to stop?
I think so.
All right. Do you think the law is trying to get at people who are might have a beer and be relaxed, that what this law is about is keeping somebody from being relaxed or feeling any effect from alcohol at all?
I don't think that's what the intent of the law. I think that the law may be so aggressive that it oftentimes does capture those people.
Okay, all right. Basically, we're trying to prevent conduct out there on the roadway, like what? Say weeding? Does that come to your mind? Driving too fast, driving recklessly. Does that come to your mind?
Exactly.
Okay. and all the things that go with it. And when someone's had enough alcohol that they've lost the normal use of their mental and physical faculty. The prosecutor explained that very well, and I'm not going to belabor that point. Go over that again with you. But I want to be sure we understand that those faculties are lost. That we have an impairment, not some vague feeling or change of mood. I want that to be clear to you, that what we're talking about, as Mr. Burleson has put it so well, is dealing with conduct impairment in an ability to operate a motor vehicle. Is that what you understand, Mr. The law to be?
Yes, sir.
Thank you, sir. Now, how do you go about proving this offense? As Ms. Foster told you, there are several elements she has to prove. Person operated a motor vehicle, a public roadway, Austin, Travis County, Texas. While under the influence of alcohol to the extent that they lost the normal use of their mental and physical faculties, or had a blood alcohol content of 0.10. Do you know what 0.10 means, Ms. Ford?
No, but they tell me it has something to do with blowing into some
Right.
machine.
Right, and I am reminded that there are so many steps to the operation of this instrument. I'm reminded that there's an old lawyer who's gone on to his reward named Roy Martin, who used to say, 7 easy steps. It's like making biscuits, and he had a gravelly voice. He had a little throat cancer in his younger days, and he'd say, 7 easy steps. But some make good biscuits and some make bad. Are you willing? My point is, Ms. Ford, you kind of brought that up when you were answering the prosecutor's questions. Are you willing to listen carefully to how this intoxilizer, used to be a breathalyzer, used to be a drunkalizer?
Your Honor, I would object to characterization of those instruments as other instruments. What we're talking about is an intoxilizer. It is not previous instruments. Thank you.
At any rate, some kind of izer.
Excuse me, I'd like to,
Brittain.
that sidebar comments and the council's comments about the intoxilizer would be strict for the record. The jury instructed to disregard those statements.
Your Honor, is the prosecutor trying to suggest that there were not prior instruments?
No, Your Honor.
That's all I'm suggesting, is that there are other instruments used. And I apologize if I misled the jury.
This point in trial, they're just not relevant. They may be relevant later.
Would you listen carefully to the testimony of these experts and determine whether or not, in your mind, based on the testimony presented to you in the cross-examination, you can determine how much blood there is, how much alcohol there is in the blood of a person, in that person's brain? While I'm there, Ms. Ford, does it matter how much alcohol there is in someone's blood in their toe, in terms of what we're looking at here today?
I just don't understand this whole.
Well, and I appreciate that, and that's what I'm trying to get to here. That you will listen to the testimony of the experts and make up your own mind as a juror whether or not that instrument, it's called, is subject to belief, and whether or not somebody ought to be convicted beyond a reasonable doubt of a very serious criminal offense based on so much breath, alcohol being in that, lights changing colors, that being some ratio to the blood.
Maybe approach, I'd like to object.
Okay.
Approach, Your Honor, I'd like to, I think Mr. Brittain is mischaracterizing the law. What he's trying to do is contract with his juror, ease that juror over to the fact that she should not consider this type of instrument
She's
at
right
all.
there, Judge, I am.
And that's not what voir dire is all about, and it's not a proper characterization of the law. He's asking them to disregard the law. If the state proves the predicate for the intoxilizer result, we get to get that result in.
I'm asking
Whether
if she has a
chooses to.
predisposition, that's all, and I'm asking her if she'll listen to all the testimony. And some of that stuff about that instrument is silly, and I want to know if she'll listen to the silliness before she makes up her mind whether that instrument's going to be the basis of it. I didn't ask her how she was going to vote or contract with her. If she thought this, or this, she would vote a certain way. That's what contracting is. May I proceed, Your Honor?
Well, I'm not going to let you characterize it as silly as long as...
Well, I apologize, Judge. It's unusual.
Don't contract with the jury.
I won't, Judge.
Tell them, in your opinion, that the machine is silly.
Thank you, Your Honor.
Right.
Mr. Brittain's opinion in this instance is not important.
Let's go.
Thank you, Judge.
Ms. Brittain, you have 1 minute left.
Thank you.
I'm just kidding.
Thank you, Judge. Would everybody on the jury panel agree to listen to all the testimony concerning these instruments before they determine whether or not they're subject to belief, and whether or not you ought to base a verdict on such testimony? Would everybody agree with me that they could do that? Thank
Well,
you.
are you gonna bring somebody of your own to come in and tell us, are we listen to this one person, or are we gonna have more than one person to listen?
I'll tell you what, Ms. Ford, that is a good question, and it reaches about 2 or 3 things that I'm going to be talking about. And I don't mean to not answer you or ignore you, but because it reaches the presumption of innocence, the burden of proof, and also something about this instrument, I'm going to wait just a second to answer your question, but in fact, it's almost too good a question because it covers a broad range. Let me go through that presentation, and I'll come back to you and see if you still have that concern. Now, the other approach that the prosecutor can take in proving beyond a reasonable doubt, or proving by the standard of proof required by law that a person's intoxicated, is opinion testimony. Testimony that can be based on field tests or observation. The prosecutor alluded to that. Again, a simple question. I'll ask you, Mr. Byrd. The fact that a person has an opinion, whether they be a police officer or an expert, a weatherman, a lawyer, whatever, in a case where you have taken that oath to a true verdict rendered based on the law and the evidence in the case, would you simply take the opinion and rule on that basis, or would you look behind the opinion, look for the basis of the opinion to see if it has been accurately formed?
Sure. I'd like that.
I could have an opinion it's snowing outside. I don't mean to be facetious, but unless, and I may be a weatherman, I may be real good about that sort of thing, but unless I give you some reason, some basis that satisfies you that in fact it is.
Right. I don't believe everything I read.
Yes, sir. Thank you. Everybody else on the panel, same question basically. If you have any difficulty with that, you'd look behind the opinion. You'd see how long it took to form it, what was observed, whether it was done carefully before you based a verdict on such an opinion. Everybody do that? You seem to have a question. Yes, sir.
I don't see how that has to do with whether he's drinking or not.
Well, see, the only evidence basically that you're going to hear in this case from the state side will be the opinion of an officer based on his observation or lack thereof. That's what I'm talking about. And a test result, if it is admitted into evidence of a particular instrument. That will be the basis for making a decision. Could you make a decision on that basis? And in fairness to the state, she has a right to know that you could render a verdict on that type of evidence. I'm asking from the defense standpoint whether or not you would look behind these opinions to see that they are based on something. Could you do that?
I think I could.
Thank you, sir. A couple of things have been mentioned about burden of proof and presumption of innocence. And it's pretty easy to talk about those things. Since, I guess, the 7th or 8th grade, we've heard about you're innocent until proven guilty. All of that sounds nice, but it's just not, doesn't have much to do with the real world. There is, I think it's fair to say, a presumption of guilt in cases. You come in, at least it would be in my case, you come into a courtroom, you see police officers over there, and you see a prosecutor, and you see somebody sitting over here in this chair. Why is he here if he hasn't done something wrong? It's sort of common sense. Why was he arrested? Not necessarily that you formed an opinion to render a verdict, but there's more or less a presumption that something has been done wrong or we wouldn't be here. So this presumption of innocence is not just a phrase that we throw out or something nice to say about how our judicial system operates. It actually takes an effort. It's a step that you have to take. To take that oath, to do what I am going to swear to that judge and to those lawyers, Mr. Alvarez, that I'm going to do. I have to say, I presume this person to be not guilty, nobody's innocent, I suppose, except maybe one, until the state of Texas proves otherwise. Do you understand what I'm saying? Does everybody think that they can do that at this point? Just take all the common sense notions you may have and say, I am going to say the slate is clean at this stage until something's written on it. And that writing will come from that witness stand, competent evidence. Everyone can do that. Let's bring that home a little bit. Mr. Burleson, if you had to render a verdict right now today, what would your verdict be?
Not guilty.
And why is that, sir?
I guess I haven't heard anything.
There's nothing on the slate. Right. The fact that the county attorney has read you a complaint and information, that's not evidence. In fact, she told you that. That's just like a civil lawsuit. That's a way to get into court, and it's a way to give the defendant notice, which he's entitled to, of what he's charged with. Do you understand that?
Right.
All right. Now, how do you write on the slate? How much do you have to write? How does it have to be written so that you can render a verdict? Before the state of Texas has met its burden, it must prove beyond a reasonable doubt that a person has committed an offense. Again, easy to say, and there's no definition in the court's charge about what that means, so it's basically what it is to each of you. But I think it's important to think about it at this stage, before you take the oath, how serious that burden is. The prosecutor mentioned to you that in civil cases, other cases, there are different burdens, like preponderance of the evidence. A preponderance is 51%. Whichever side proves the greater weight of the evidence, they win. Not so in a criminal case. There are some quasi-civil cases where the burden of proof is clear and convincing evidence. Again, not in a criminal case. Beyond any reasonable doubt. Now, why is that? Why is the burden so severe? Because we're talking about a person's criminal record, potentially their liberty. Obviously, we're not simply talking about perhaps money damages or something like that. We're talking about liberty. That's why the burden is where it is. Now, let me try to make that perhaps make a little bit more sense to you. Mr. Byrd, you listen to all the evidence in this case for the next day and a half. You go back to deliberate, and you find that Mr. Alvarez, in your opinion, based on the evidence, following that oath, by a preponderance of the evidence, by the greater weight of the evidence, was driving while intoxicated. But you have a reasonable doubt thereof. What's your verdict?
Not guilty.
Yes, sir. Does everyone understand that? Mr. Burris.
5 minutes.
Thank you, Your Honor. You go back there and you sit down and you look at all the evidence and you determine as a juror, and it is an individual verdict. It's your decision. You're to deliberate, to talk, and share your ideas with the other jurors, of course. It is an individual matter, and you determine in your individual decision-making process that the evidence is clear and convincing to you that Mr. Alvarez was intoxicated, operating a motor vehicle. But you have a reasonable doubt thereof. What's your verdict?
Not guilty.
Thank you, sir. If you've listened to all the evidence and you find that it satisfies that burden, of course, your verdict is guilty. Now, is there anyone on the panel who does not drive? No. Okay, you all operate a motor vehicle. Have you ever had occasion, Mr. Byrd, to go maybe 5 miles over the speed limit?
Sure.
Maybe go 10 or so inches over the little white pedestrian crossing line? Have you ever done that, Mr. Burleson, when you stop? Sure. Kind of an everyday thing. How about making a wide turn, Mr. Daly, as you're coming up? Have you ever done that in your lifetime?
Yes, sir.
Any of you consider that particularly outrageous or unusual in terms of normal operation of a motor vehicle? Okay. Let me just touch on something very briefly. My client has been in the process before. He has. I want to bring this out to you. He's expected he may testify in this case. You have a right to know that he's been convicted of shoplifting years ago. Some circumstances related to that, but that's not important. The fact is, he has a Class C misdemeanor at the same level of a traffic ticket conviction, and it didn't have anything to do with alcohol or driving or DWI. Is anyone on the panel that would take that into consideration in following their oath, that make any difference to you in terms of whether or not this man is guilty of the offense he's on trial for today? You all tell me that wouldn't even come up in your deliberations? Thank you. All right. There are a lot of different ways to approach this idea of whether someone's intoxicated, and a lot of different ways to define intoxication. But I'm pleased to say that we've passed the day where people ask trick questions and go into things like, how much do you normally drink and what's your brand, to try to make them look like an alcoholic, and you know, if you feel anything at all, are you drunk? Prosecutors, thank goodness, and defense attorneys have left that period where you go into these trick questions. I know what Ms. Foster's going to do and what I'm going to do.
Your Honor, I'm going to object. Mr. Brittain has no idea what I'm going to do. And I'd ask that
I stand corrected.
that his opinion as to what our questions are and what our is irrelevant to this entire proceeding.
I apologize. I was trying to brag on her a little bit, Judge. She's such a good prosecutor, and I know she's going to be fair, and you're going to sense it as she tries this case.
Your Honor, I'd like a ruling on that.
Thank you very much. That's all I have.
All right. Questions? Open it up for questions. Anybody?
Is it normally that easy to get people talking to you?
Ann?
Oh.
And Steve?
Oh,
These
I can't
questions.
think of
I'm talking to you.
It depends. Every panel's different, and every, you know, people are, sometimes you can't get them to shut up.
Yeah, that's true, and sometimes you want them to shut up.
Like that question, off-the-wall question, it takes you a while to realize that you don't have to lower yourself to their level. Good question, appreciate you. I'm going to get back to that later. Of course, you never do. Just shut up. I've got other things I want to talk about. Don't get caught up in it.
Yeah, no, just talk.
How do you, in terms of like bringing up a negative aspect of your client, how do you, I mean, I know we've been taught that you should bring it up and let them know about it. Well, how do you feel about making, since it's kind of irrelevant, making the state or your opposition bring it up and make them look like they're trying to beat up on the guy or whatever, instead of, if it's irrelevant, let them bring it up and trivialize it.
You talking about shoplifting?
Right. Got the sponsorship.
Well, they can't, normally, they can't bring it up on voir dire because they don't know for sure that he's going to take the stand. I mean, oftentimes they are not able to bring it up. And if you don't bring it up at voir dire and they hear about it later, it depends on them. They may feel like you hid the ball and that they brought out something, you know, that we didn't want you to know about. Jurors don't consider anything irrelevant. When you object to relevancy and it's sustained, that's the part they remember the most because somebody didn't want them to hear that. They don't have any concept of relevancy. They like it all.
Well, I disagree. I think that sometimes they will consider it, but if the judge instructs them not to consider it, a lot jurors really want to do what judges tell them to do. Judges, unfortunately or fortunately, have a lot of power, and jurors really want to do what the judge asks them to do. And I think they often make a conscious effort to say, no, we are not to consider that. Let's sit it out. So, but in terms of if you've got something wrong with your case, from my point of view, I think sometimes, depending on what it is, it's good to get it out and desensitize it. Because the more often somebody hears about it, the less important it really becomes. And they're sort of aware of it. Oh yeah, we knew that was coming. Okay, it's not that big of a deal. And it all is in how you present it throughout the trial, starting at voir dire all the way through. You got to have a theory about what you're going to do. You sort of can't say, oh yeah, well, by the way.
One juror out of 1,000 is going to say, he's a thief? A thief? Well, I ain't going to know. I'm not.
Yeah.
I can't be fair to a thief. You know, you found something that you wouldn't have found otherwise.
If you decide after a couple of questions that you know you're going to have to try to strike someone, do you at that point just sort of start ignoring them and just don't ask them any questions or ask their opinion anymore? Or should you still every now and then ask them questions to not make them feel left out?
From my point of view, if you know that you're going to strike someone, you ought to try to see if you can't get them for cause. And there's a way you have to sort of, there's some questions that you can ask them to lead them down that path and commit them into a cause situation, and then you leave them alone. And if they start answering your questions, raising their hand, you don't want to rehabilitate them, or you don't want to have the opportunity to rehabilitate them, and you don't want them to rehabilitate them. You want to commit them to the bias or prejudice and then leave them alone. And usually you know who of your panel is going to be good for you or not. And on this panel, poor Mr. Bailey, I mean, kind of like what I might want on my jury, but he's really kind of a kook at the same time. So you know that he's going to be brought up for cause, and you try to soften him in that way. But usually the strike pattern, you really, you know, you have an idea of what, just a general strike, you have an idea, but then you never really make up your mind about that until the other person's done their voir dire, because things happen and you may be there may be other things that you find out from that person that balance it. Just because they're bad on one thing doesn't necessarily mean they're bad on all.
Do you strike for cause, do you try to get them for cause immediately, so you can, so they can be released, or is that not a good deal?
I don't know, I think the people I've gotten for cause are pretty, sort of, you can tell, you really can tell if you need to get them for cause or not, and you can either, my personal thing is that, it just really depends. I mean, you'll have a feel for your panel.
I mean, once you've let them and you've gotten it all out where you think that there's a good chance of having struck for cause, do you go to the judge at that point and ask for that person to be
that depends on the judge. Some judges want you to do it right then and there. My judges in county court usually wait till the end.
Assuming you had one strike apiece, would you tell those students who you would have struck and why?
Who I would strike?
Both of them.
You would have gone after him. Gone after him for I would have gone after him for cause.
Oh, Daily? Yeah.
We would have talked about sin a lot.
I probably would have struck Mrs. Ford because I thought she was really dumb. And I like smart jurors. No offense, Miss Ford.
Mark.
How about Burleson? If I was a prosecutor, I'd want to get rid of him. Frat boy, drinking, partier.
Well, yeah, I would have, but I mean, you know, between the two of them, she would have been my first pick. He was possible, but I mean, yeah, he's a frat boy, but I had forgotten about that. That's a good point, but that's why we take notes. But she stuck in my mind as worse than he. But that's why I always try to get somebody to take notes with me as second chair, because I can't remember everything these people say, and they'll go, well, wait, what about that? And you'll go, yeah, get the guy out.
You know, we talked earlier about how when you're doing your strikes, and in this case, you only have 3, right?
It's been a while, hasn't it?
Yeah. First 2 strikes, generally, the first 2 strikes aren't going to be so tough. It's that last one. If you've got 10 strikes, the first 8 aren't so hard. It's the last 2 that just spend all the time trying to figure out who to strike. Anybody else?
And let me ask you this question. It's been my perception over the years that women jurors tend to be very critical in assessing female witnesses. Do you feel that there's some kind of a plus or minus with female jurors being a woman?
Your question, me being a woman or them being a woman?
Well, I mean, do you feel like, was the fact that Ms. Ford is a woman that or
No, I just thought she was dumb. You know, one thing that picking juries has taught me is that I cannot characterize anyone about the stereotypes. Race, color, creed, background, it's really weird. No one fits those stereotypes. Some of them do, but you better watch out because they'll turn around and bite you in the ass. The fact that a juror is a woman, I personally think that women are better people, generally. And I think that they're,
Never be on the Supreme Court.
I think that,
You guys get that on TV?
I think women, this is my personal theory, okay. I think that women have spent a long time being observers and not necessarily participants, and I think we're culturalized and socialized to do that, and I think we make damn good jurors because we listen, we assess, I look at women who have that potential to do that because they listen, they're born listeners, they sort of like can, you know, that's a pile of crap or not. They're good judges of character, I think, generally. Now, here we are again in that stereotype thing. But usually if you find a smart woman, you've got a really good juror.
One of the reasons we're asking that is that when Cynthia was here 1 or 2 semesters ago, she felt like she did not relate well to female prospective jurors.
I think it's real different. I think going with your gut is real important because your jury is thinking on real different levels all the way through the trial. And I think as much they identify with the lawyers as they do with the case and evidence that you present them. And for Cynthia, yeah, I think that perhaps some woman would find her a bit too abrasive.
Talking
Or
about Cynthia Bell.
Cynthia Bell, right. And that way, and I think you just have, she knows herself well enough to know what kind of person is not going to like her and what isn't. And I think after time, you will know who doesn't like you and what kinds of people don't like you and what kinds of people do.
I like women on jury from the defense side. They're a little bit older. Some of the maternal things come out for the client, and I think they've had kids get in trouble and that sort of thing. They relate a little better to me. But, in a nutshell, real quick before we got to go, you're learning all the technical stuff and very well from pros. When you get past that, Brittain's philosophy on voir dire, like kind of said, look good and make friends. And it sounds a little bit silly. One of the things you want to do, everybody basically has some material they want to get over, and different styles of doing it. But make a good impression and make friends with the jury, and that transfers to your client. You do a little touching, verbally, physically sometimes. That lets the jury know that maybe even this mad killer, has something about it, because they tend to like you if you do your job well, and also they'll communicate better with you if you do that.
One other important thing to remember, guys, is before you get up to do your voir dire, make sure that you have your pocket. So you're sitting there fumbling, when you argue, too.
Yeah.
You don't want to be distracted if you have the jury distracted by something. Generally, you're keeping the pocket.
Okay, any other questions? Okay, thank you all.